this. These permanency hearings are creatures of statute. How the heck are you giving us a trial by jury or a court of record trial, if you're using statutes? The judge is not making a decision if something is right or wrong in the law or the facts. The judge is being forced and bound by statutes. When the judge is bound by statutes based on K.C. Davis's book, Administrative Law and Government, you find that these people are working ministerially as clerks for the involved agency. So if the agency creates if the statutes creates the agency CPS, and then CPS goes into a courtroom where a judge is bound by only statutes, the judge ain't making judgments in his judicial capacity. He's working with the contract that's created to make that agency and the funds that are coming in from the federal program. Therefore, he can't do anything but what the federal funding program says. Y'all don't believe me? Let's see. Federal law requires, as a condition of federal funding, you don't have to take the federal funding, but if you're going to take the federal funding, the condition is, federal law requires, as a condition of federal funding, that all states to comply with certain minimal procedures in abuse and neglect cases. They have to do everything that the federal government tells them to in order to get the money. So they ain't making judgments. They're just making rulings based on the process that's put in place by the federal corporation that is governing their business. So the federal corporation is giving money to them to make decisions. Let's look. We'll prove it. 675-5C1 2006. The first permanency hearing must occur within 12 months of the child's entry into foster care. See, that's the terms that are put in place in the codes and 45 CFR and Title 42. That's what's put in place by them. A judge is acting on statute alone. Now, I'm going to show y'all who the heck is doing this to us, okay? Because people want to make it look like they're giving us a fair shot. But it's a trick. Watch this. Watch this. Thinking back to my time as a trial judge, I remember a social worker, somebody coming in and arguing the individual who had been adjudicated neglectful or stipulated to neglect had once again failed to do something that they had been ordered to do by the court, and therefore they were recommending that the goal should be changed. I was never sure if there was a requirement or a notice that was given that at this hearing we were going to be discussing a change. So the judges are being told at the last minute what's going on in these so-called courts, and is based off of ASFA. It's not based off of them finding you as had done anything wrong and trying to make a decision that's fair. They're listening to the agency who comes in with the report, usually a little bit before they have to have the hearing, and then that's how they make their decisions. Now, let's talk about who is actually dealing with our court cases. Everybody want to say the state of Arizona is handling our court cases. No, the state of Arizona is not handling our court cases. No, the state of whatever you in are not handling your court cases. Who's handling your court cases? Private membership associations, private trusts, private businesses. I'm going to prove it to you. Don't take my word for it, please. Let's look. The National Council of Juvenile and Family Court Judges. What is that? The National Council of Juvenile and Family Court Judges, a what? Membership organization of courts handling abuse, neglect, juvenile delinquency, and other cases. Wait, did this say the National Council of Juvenile and Family Court Judges, a membership organization of courts? Or did it say the state of Arizona Superior Court, the state of Kansas Superior Court, the judges of the state of Nebraska? No, it did not freaking say a state, okay? It did not say a state at all. What it clearly said was the National Council of Juvenile Family Court Judges, a membership organization of courts, okay? They're not courts. They're a group of people who come together as a membership organization who has members, okay? They have members. And these members are people who are coming together and making decisions for your family and for your kids in an administrative hearing that they make look like it's a court. How do you know they're making it look like it's a court, David? Watch this. They provide technical assistance to judges nationwide, has issued guidance for permanency hearings. How the heck do they guide judges if they're acting in their judicial capacity? They wouldn't be. that echoes the law in the District of Columbia. The council urges judges. What the freak do you mean urges judges? Watch this. Urges judges to make written findings of fact and conclusion of law. Well, dang, a real judge would already have findings of facts and conclusion of law. Why the heck you got to get these members to write, the judges who are members of these organizations, private membership organizations at that, which they traffic us into, and I'll explain that in a little while, including whether the state agency, see, the state agency is created by statute or a private business, so they're not a state agency. They are not the freak state. Stop believing this garbage that the state is coming after you. There is no state coming after you when your court case says in the matter of your kids in the county of some capital letter name all the way across it. And then all you see is that you have private parties coming in there, judges not using their real name that they normally use on a roll of attorneys, attorneys not using their normal name on a roll of attorneys. They're doing this because they're doing private business. They're jacking you of your kids. They are raping you, just like the Administrative Procedures Act said, and just like the people said in history, the attorneys and the president. Watch this. Whether the state agency has made reasonable efforts to help the family unify. Now, if it's a private business and it's a private membership association and they're all part of it, hold on, let me wipe my lens off, sorry. If they're all a part of it, why is the one who's coming against you as an adversary also the one who's providing you services? Don't businesses provide services? Yes, all they're doing is providing services to you at the barrel of a gun. They steal your kid first, then they provide you services. But they never took you to court. Watch this. The council has admonished members. What? The National Council of Juvenile and Family Court Judges. The council has admonished members that permanency hearing findings should be more specific, final, and definitive than a review hearing. They're telling them how to perform, guys. They're telling them how to perform. But the council's description of permanency hearings lack any reference to examination of witnesses. They're not even saying that you have to examine witnesses, documentary evidence. Y'all wondering why you can't get evidence into the courts. This is why they don't give a freak about documentary evidence or other trial type procedures. There's no mention to trial type procedures, not trials, trial type procedures, because this association can't give you a trial. It cannot give you a trial. It gives you trial type procedures. Now, this goes back to the Administrative Procedures Act, because the Administrative Procedures Act tells you that they're not giving real trials. They're giving trial-like hearings. It looks like a trial, smells like a trial, but it ain't a real trial. Now, we got to go deeper, y'all. We got to go deeper. Watch this. The council also does not specify what detailed factual finding would justify a particular permanency plan ruling. They're just trying to find permanency. You think they're trying to put you in jail? No, they're just trying to find permanency. How to get your kid out your freaking house and into somebody else's house where it's permanent so they can adopt and make money. That's what the business is about. Instead, the council writes that state agencies should propose their recommended permanency plans to all parties in hearings, and the other party should submit a report if they disagree with the state's proposal. It ain't the state, it's the private company. Watch this. Such reports should set out facts to support the party's position. The council guidance includes no discussion as how courts are to determine whether a party's view of the facts is accurate. They're not trying to see if you're right or not. They're not trying to see if CPS is correct or you're correct. They don't give a darn about evidence because it's not a real freaking court. And you're in there talking about my case. The evidence says that I was right. No, the evidence says you were right. No, the evidence says nobody's using evidence. Let's stop talking about all this evidence and let's deal with the fact that they're stealing our kids and in a legitimate court. Period. Okay? Period. They're not looking at you about evidence. They just want you to think that's happening, because if they do, they can keep you caught up in everything that's going on. You'll never realize they're just rehoming your kids for a business. Now, nor does the council suggest how to respond to delayed or incomplete agency reports. See, your agency Don't turn in your CPS reports. Don't turn in the fact that you did all your services. Don't turn in all that, because they don't give a darn, and nobody's doing anything to them if they don't. So we're arguing over the wrong things. Everybody's arguing over who's the smartest. Everybody's arguing over who's the best at doing their documents, and who's this and who's that, and who can write the best briefs. Screw the briefs. You ain't in court. We're not in court. We're in the midst of a private membership association that is tricking us to believing that it's court. Now watch this. The council guidance also includes no suggestion that permanency hearing rulings are subject to appeal. If they put your kid somewhere and say this is for permanency, you can't even appeal that. This guidance speaks of appeals from adoptions and terminations of parental rights. They say you can appeal adoptions and termination of parental rights, but not appeals of permanency hearing decisions. In addition, the federally required, this is a federal program, this ain't no court, guys. Permanency hearings, many states require review of disposition hearings, and these review hearings often overlap permanency hearings. So guys, people keep trying to tell us we're in a court, all right? They keep telling us, but we're not freaking in a court. We're not. Watch this. Although significant state-by-state variations exist, the law of the District of Columbia and the recommendations summarized by the National Council of Juvenile Family Court Judges are illustrative. Now, we're going to jump to, I think it's page 28 or 30. And I'm sorry, guys, I'm going so fast, but this is some real stuff that we need to realize is happening. Now, this is in their own scholarly journal articles explaining what's happening in these fake courts. Watch this. The standards or lack thereof summarized above govern all decisions made at permanency hearings. So there's a lack of standards for permanency hearings, and they're admitting it, including both permanency plan decisions and decisions whether administrative agencies have made reasonable efforts to achieve a child's existing permanency plan. It is not surprising, therefore, that state courts implementation of federal reasonable efforts. So the state courts handling federal issues, okay? It's not a state issue, it's a federal issue. The state is just following suit because that's how they get the money. Reasonable efforts requirement has faced criticism. Why? Same thing y'all been telling me. As substance-free rubber stamp decisions by state judges. The judges are making decisions based on some bullcrap. A significant, and they're letting people they're rubber stamping whatever these agencies want. A significant problem given the importance of reasonable efforts in the federal statutory scheme. They're going by federal statute, not the state. And the unavailability, see, we ain't got no remedies, y'all. Watch. And the unavailability of remedies to enforce states' reasonable efforts obligations. There's nobody you could go to in the federal government to tell. Why? Yes, ma'am, I'll get you one. There's nobody to go to because it's a federal corporation, it's a private business, and nobody can hold them accountable. In the absence of a federal definition of the term or adequate federal funding for the prevention or reunification of services, judicial findings of reasonable efforts are often made by judges by rote. That means they're just mechanically doing it. But they can't make an order because they are also parties who are making money off of Title 42 Title 4E program funds. Their orders are null and void. When such decisions cannot be appealed until the end of a case, watch what they do, y'all. When an adoption decree or termination of parental rights decision is entered, appellate judges face strong incentives to avoid close examination of reasonable efforts decisions. Y'all want to know why I didn't do an appeal? Because the appeals court is really not doing their part, because they're looking to see if the administrative agency went by their own process when they're going to cook the record to say whatever they wanted to say. Early in the case, let's see, overturning a permanency decision based on lack of reasonable effort early in the case could upset stability for a child who has been previously neglected or abused. But the problem is, y'all ain't proven that people have neglected their kids. Okay? Y'all not doing that. Watch this. A full exploration of the right to counsel throughout a dependency case is beyond the scope of this article, except to note the correlation between the right to counsel and the right to put on and challenge evidence, and thus between states that have disregarded informed opinion, which has clearly come to hold that an indigent parent is entitled to the assistance of appointed counsel. Watch this. In dependency and neglect proceedings, and those that do not see the value in basing permanency hearing decisions on evidence. They're not looking at the evidence. We're trying to prove stuff with evidence like, hey, I'm not guilty. I'm not wrong. I didn't do anything wrong. Y'all know I didn't do anything wrong. But they ain't looking for that. They're not looking for that. You in the wrong court arguing the wrong thing because this ain't even what it's about. Now, I'm going to show you a little bit more and I'm going to let y'all roll. Among states that do not permit parties to appeal permanency hearing orders, the most frequent analysis in such decisions are not final orders. Thus, appellate courts lack jurisdiction over appeals of these orders. The policy concern animating this approach is taking the time to appeal such plans makes little sense when trial courts face strict federal timelines. They're only working based off the federal statutes. That's why they're doing all the stuff they do as a condition, as I showed you earlier, for getting money. For moving toward permanency, an Arizona appellate court worried that permitting such appeals would undermine the primary purpose of ASFA, the Adoption of Safe Families Act, the federal funding incentives, and conforming Arizona law, expediting the process of finding permanent placement for children. That court did not discuss the reality that we have already seen, that even with ASFA timelines, a significant number of children remain in foster care for an extended period of time. States like Arizona that have held that permanency plan orders are not appealable include these. I'll just let y'all see that. Just so you can see it for your state. But guys, this is a big issue. We are being tricked. We are being deceived, and we don't have any remedies because this is a purposeful thing that was done a long time ago to stop us from being able to make a case to have our little ones. This is all it is. This is all it is. They're a private membership organization acting like they're in court, and they're not. And they trick us to think we're in court. They talk to you a little bit about stuff like you did stuff wrong. We believe you did this. We believe you did that. They don't care if you did this or not. Their whole job is to take your kids out the house, get them in another house so that they can hurry up and get ASFA